Mr. Noonan.
Okay.
You reviewed depositions and all the exhibits in this case, right?
I mean, you'd have to be more specific. I can
Okay.
confirm or deny what I reviewed.
You reviewed the depositions of Ms. Christy Folatanova, Tracy Simon, as well as plaintiff Bobby Daly,
That's correct.
and you reviewed some advertisements from the defendant's shop, located at the defendant's shop.
You'd have to be more specific about the advertisement.
You reviewed it. Okay. I'm gonna move on because I didn't write this part down yet. I just thought about it before I came in here.
You show them the.
You prepared a report.
I did.
Okay. And in that report, you gave an opinion.
That's correct.
Okay. Now, Mr. Noonan, it is your opinion that Miss Daly was a trespasser when she was attacked on June 6, 2015, right?
That is my opinion, yes.
Okay, and you based that opinion on the fact that the store had closed and Mrs. Daly had been asked to leave, right?
Yes.
Okay. So, you know that there was a promotion going on June 6, 2015 at Scooter Ice Cream Parlor, right?
Yes.
Okay, and that promotion was related to the Chase-In game?
That's correct.
And you're at least somewhat familiar with the Chase-In game,
I'm somewhat familiar, yes.
at least as much as it relates to the situation here today.
That's correct.
Now, you reviewed the deposition of Ms. Christy Folatanova,
Yes.
and you reviewed the deposition of Ms. Bobby Daly.
That's correct.
Okay. Now, you also know that the nature of this game is that it puts a virtual location in the real world.
Yes.
Okay, and those virtual locations are called chase places.
Yes.
And one of those places was located outside of Scooter's Ice Cream Parlor on June 6, 2015.
That's correct.
Now, I'm handing you, permission to promote your witness. I'm handing you the advertisement that was located in Scooter's Ice Cream Parlor on June 6, 2015.
Okay.
And this ad says that you want to chase some monsters? You chase some monsters, we got them, right?
That's correct.
Okay, and it offers that if you catch a rare chase monster, your order is free.
Yes.
But on the same advertisement, it doesn't say that the store closes at 10 o'clock, right?
No, there's no reference to that.
Okay, and it doesn't say that the promotion ends at 10 o'clock,
No, it doesn't say that.
and it also doesn't say that you can't redeem your free order on the following day, right?
I don't know what you mean.
The advertisement does not say when you can redeem your prize, when you
No.
have to redeem your prize.
It doesn't refer to time.
Okay. Now, it also doesn't say that after 10 p.m. you're trespassing, right?
No, it doesn't say that.
Okay. Now, based on your review of the record, you know that Chase-'em is not controlled by the defendant, right?
That's correct.
And the game does not shut off at 10 p.m.
Not as far as I know.
Okay. And Mr. Noonan, you're not aware of any fences located outside of Scooter's Ice Cream Parlor, right?
I'm not aware of any, no.
Okay. And you're not aware of any trespassing signs.
No, I'm not aware of any.
Okay.
In
Now,
fact, I believe there's an indication in the police report that there was no trespassing signs. Perhaps it's something to keep in mind.
okay. I'm going to think about that at a later time, Mr. Noonan, so thank you for that. Now, I'd like to talk to you about some of the security measures that were in place at Scooters on June 6, 2015.
Okay.
Now, two things that you mentioned were cameras and lighting.
Okay.
So let's first talk about those cameras. I'm sorry, I'm going to take this from you now. Thank you for that. Now, the cameras. You mentioned that cameras act as a deterrent, right?
That's right.
Their primary purpose is to deter crime from occurring.
Right.
And the idea behind that is that if someone sees the security cameras, they are less likely to commit a crime.
Right.
Okay. They don't want to get caught. Now, The defendant had 2 cameras located outside their property on June 6, 2015, right?
That's right.
And they're located here and here?
That's right.
Okay. Now, those are both on the same side of the building, right?
Right.
And there's no security cameras here, right?
On that side, no.
And there's no security cameras on this side of the wall
No.
of the building.
There are not.
Okay, and there's also no security cameras on this side of the wall of the building.
No.
Okay. Now, you know, Mr. Noonan, that the defendant, that the plaintiff said that she was standing right here, right?
Yes.
Okay. Now, another thing that you mentioned was the lighting.
Mm-hmm.
And lighting, as well as the cameras, can act as a deterrent as well.
Yes.
Okay. Similarly, if someone thinks they're going to be seen, they're less likely to commit a crime.
That's correct.
Okay. Now, you know that there were lights in the parking lot on June 6, 2015, right?
That's right.
Okay, and that there were 6 of them located here, only 6
That's
L's.
correct. Yes.
Okay. And you actually indicated that the presence of these lights was an adequate security measure, right?
That's correct.
Okay. And you know that at 10 p.m., Ms. Daly was asked to leave scooters
That's
inside
right.
the building.
Mm-hmm.
Okay. And sometime after 10 p.m., Ms. Daly was located in the parking lot.
She went from the store to the parking lot. Yes.
Right. And at that point, Ms. Daly was located in the parking lot, and she was playing the chase and game.
That's right.
Okay. And at some point, Mr. Noonan, you know that she was asked to leave the parking lot, right?
Yes.
And she went to the sidewalk,
That's correct.
right? And you know from Ms. Daly's deposition, as well as her testimony here today, that the sidewalk was not well lit.
Based on her deposition, she indicated that the sidewalk lights were off.
Okay. Well, in fact, it is your opinion that when she was attacked, Ms. Daly was in a dark location on the sidewalk.
Yes.
Okay. Okay, so we established that she was told to leave the parking lot, right? And she was told to leave the parking lot by Ms. Christy Folatanova.
That's right.
And Ms. Christy Folatanova is an employee of Scooters,
That's right.
who is the defendant.
Yes.
I have no further questions.
So for this section, one thing you want to throw in a little bit more of is based on your review of the record.
Yes.
Or to be more accurate, based on your review of specific parts of the record.
Okay.
Instead of you know. Because this person doesn't actually know anything. Their opinion is based on what other people have told them or things that they reviewed.
Okay.
So that's how you want to be making sure that you're characterizing things, not their knowledge, but what they've learned.
Okay.
The sidewalk part, the lights are off. So you said something along the lines of,
It was not well lit.
it was not well lit.
The
Lights were
sidewalk
off.
was off.
So based on your review of Ms. Daly's deposition, you know that you learned that the sidewalk lights were off. In fact, you believe that she was attacked in a dark area, right? Right. And that's the other way I would put that, is not, it's your opinion, but
Yeah.
you believe.
Okay.
What you want to make sure that the ending of it, I think you said something along the lines that she was an employee of Scooters.
Mm-hmm.
She was the defendant's employee. I think you do it in 2 questions.
Yeah.
She's so in the parking lot, goes to the sidewalk lights are off, you think it was dark. Now she went from the parking lot to the sidewalk because she was told to leave by Christy Folatanova, right? Right. Christy Folatanova is the defendant's employee, right? Right, yes.
And that was when Ms. Christy and Ms. Christy Folatanova is the employee. Okay. I have that written here, I just didn't say that out loud.
That's fine. I'm trying to think earlier on. The stuff that you tried to add at the beginning is not necessary.
I didn't know if I should like talk to you about, because I feel like it's just coming in awkward.
Well, during the direct, they're going to say they reviewed some materials, right?
Mhm.
And at any point that you want to go over, which you do, you'll talk about materials they reviewed. So you don't need to do an overarching material review. You just do it for each thing you want to talk about. So, you know, if you're going to talk about the distinction between Fulton Nova and Daly, then you say you reviewed Fulton Nova's deposition, you reviewed Daly's deposition. You don't have to go through all of it at the beginning.
Well, so should I say then that you gave an opinion?
Well,
Because
so when you
I feel like it's opening to like just that first opinion question, and it's like not, there's nothing building it up.
well, you could say, now you wrote a report in this case,
Mm-hmm.
and in that report you stated your opinion.
Okay.
Now, one of your opinions is that Miss Daly was trespassing the night of June 6th, when she was attacked on June 6th, right? Right. And then the basis of that is blah, right? Right.
Okay.
So you can do it that way.
Okay.
And the only reason why we're setting that up that way now is because we don't always necessarily know how they're going to do their direct. If the direct is they're trespassing, then you could say, now you testified today that you believe she was a trespasser, right? Right? So you don't need to do, you wrote a report.
Okay.
Right now we're setting it up with the report on the off chance that they don't talk about trespassing at all.
Okay.
So, so it would adapt if it's talked about in the direct. Let's see. Don't think there was any problems from there. The trespassing part, I think was okay, and then the second part.
Oh,
was
I
the
had a question about the cameras.
Yeah.
I went back in my notes, and then we ended with, you know, that there's no cameras on the side of the building, and then I went right into the lighting. I added just now about knowing the plaintiff was standing at the exit. Should I ask the other question of the cameras face the parking lot?
I don't think so. It's not necessary.
So then do I not need that the plaintiff said she was standing here?
Well, the idea is that I like that the plaintiff was standing here because that sets up that the plaintiff says the lights were off, and that
Okay.
and that they think it's dark. So I see that not as a distinct fact that the plaintiff was standing there, but as a transition into the idea that she went from light to dark, and she
Okay.
went from light to dark because the defendant told her to. And
Okay.
you just need to make that clear in the closing that she was she was in the lit area looking out for herself. So, and this becomes, remember when we talk about the distinct sections of the closing, part of the closing is attacking the defense's argument. And in the attack of the defense's argument, you would say, now, their suggestion is that she was not looking out for herself. But remember what happened. She was originally went into the parking lot. The parking lot was well lit. She would have been able to see an attacker coming. But she was told to leave the parking lot. She was told to go to the sidewalk. The sidewalk was not well lit. And so if their suggestion is she should have taken care of herself, perhaps we should put a little bit of the blame on the defendant for having their employee tell her to go to the less well lit area.
Okay.
So that way when someone's coming, she would have more than just a split second to defend herself.
Okay.
Because she would have seen them coming from a little bit longer away.
Okay.
That's where you make that argument clear, is that you set that up in the attack of the defendant's thing. But you have to make that clear, because if they didn't get it right away in the cross, you want to make sure that you say, now when we cross-examine the defendant's expert, we went through what happened. Right? And that's how you attack the defendant's
Okay.
argument, is that they forced her to go in. So when they say that the plaintiff didn't take care of herself, you say, yeah, but the defendant forced her to be in that position.
Okay.